Yeah. Hello, good evening, everyone. I hope you all had a refreshing tea break. So, we will begin with our second panel for today, which is Trial and Evaluations by Children Courts, Process, Practice, and Challenges. The panel will be moderated by Ms. Bharti Ali, who is a development professional and has worked on gender and children rights for over 3 decades now. She's been part of several government and non-governmental bodies as a child rights expert, contributing to development of law and policy, research and training, particularly on child protection and access to justice. She is currently one of the directors of Help for Children in Need Foundation, HCNF, and an independent consultant with different organizations, including Enfold. On our panel today, we have Dr. Aarti Mundkur. She's an assistant professor at NLSIU. She's also a lawyer and a researcher and is a founding member of the Alternative Law Forum, Bangalore. And she has worked extensively on issues of women and violence and later established her own legal practice. With over 18 years of litigation experience, her work spans family law, juvenile justice, and criminal law. She has also served on the Juvenile Justice Board, Bangalore, and represented CCLs and children in need of care and protection. Next, we have Shri Samresh Singh Kushwah, who is presently serving as the District Judge, Sagar, Madhya Pradesh. He belongs to the 2008 batch of the Madhya Pradesh Judicial Service. Earlier, he held the post of Registrar Judicial High Court of Madhya Pradesh and also served as Secretary of the JJC High Court of Madhya Pradesh. During his tenure as Secretary of the JJC, his responsibilities included implementation of the State Action Plan, monitoring the functioning of the JJBs and CWCs, and addressing complaints and issues relating to various stakeholders under the JJ framework. Earlier, during his district posting at Bhind, he had served as a POXO judge and presided over the children's court there, dealing extensively with matters related to child protection and offences against children. Mr. Rohit Thakur, who is a legal and social work professional currently serving as a probation officer at the Govt.Special Home for Boys, Jagdalpur, under the Department of Women and Child Development, Chhattisgarh. He holds academic qualifications in law, social work, sociology, and computer applications. Appointed in 2019, he has over 4 years of experience in his current role, working closely with children in conflict. Prior to this, he has spent 7 years working with a civil society organization in Jagdalpur as a coordinator, engaging in community-based social work and outreach programs with children, adolescents, and women. Ms. Sneha Singh is a Delhi-based criminal justice and child rights lawyer practicing for over a decade in trial courts, children's courts, juvenile justice boards, and the Honorable Delhi High Court. She has investigated the conditions of legal aid for children in conflict with law in Delhi as a member of the Justice Madan Lokar Inquiry Commission set up in 2022 by Delhi Commission for Protection of Child Rights. At present, she is part of the Delhi High Court's legal aid program for prisoners in Delhi prisons. Apart from the litigation, she also trains child protection functionaries from across the country. Mr. Sandeep Hari, a fair trial advocate and access to justice for prisoners at Nalsar. He's been working with children from underprivileged backgrounds through NGO Spurti Foundation in Hyderabad since the past 18 years. He's completed his LLM in criminal law from Osmania University, and he's a practicing advocate at various district courts in Telangana. In AJP, he has been working on cases of CCLs at Rangareddy and Medchal JJBs, more specifically on bails and inquiries of CCL cases. He's been practicing as an advocate since the past 5 years. We welcome you all.
Well, post-lunch, I'm sure, was difficult for everyone, but I hope the tea has given us enough energy to get back into the session. As you all have seen the program, this is about trial and evaluations by Children's Court, and we have vast experience here. And it becomes equally difficult then for a moderator to sort of decide on what to ask and whom to ask. So 3 basic questions is what we are going to have today, which all of you can answer. In fact, the second question is not for everyone. That's more specific to Rohit, because Rohit brings in the experience of being a probation officer working very closely with children. So my first question to the panelists today is, what is the current situation and current practices by children's courts once a case is transferred by the JJB, with specific focus on practices around appeal, around review of the transfer order and the PA, and then decision to conduct an inquiry as a board, and then to conduct a trial as an adult. So with respect to 4 of these aspects, there is a 5th aspect. I don't know if we have time for it or not, but that is when, an evaluation has to be done when the child who is found guilty completes the age of 21 years. We'll come to that later, but at the moment, with respect to appeal, review, and in conducting inquiry, conducting trial. We'll start with Samresh sir. आपसे start करें. Thank you.
Dignitaries on the dais and off the dais. Namaskar to everyone. Before coming to my topic, I just wanted to make clear one thing that in first session, Mr. Arul Verma has said that in MP, out of 100 cases, 80 cases are referred to Children's Court during preliminary assessment. That data is not correct. I am stating the correct data. Uh, uh, Principal Magistrate Bhopal is here, and out of 90 cases, she has referred only 5 cases to Children's Court. So that is not the correct reflection which was said in the first session. Coming to my topic, I just wanted to make clear that I would divide these challenges before Children's Court into two groups. First one is process level challenges, statutory design versus ground reality, and second is practical level challenges functioning inside the courtroom. So, in first topic, that is process level challenges. In MP, there is an absence of designated children's court in Madhya Pradesh. So, although the Juvenile Justice Act and Commissions for Protection of Child Right Act 2005 in Vizag designated children courts, Madhya Pradesh does not have exclusive or formally notified children's court. Instead, all session courts exercise children courts powers. This has diluted judicial specialization, weakened institutional identity, and reduced effective accountability and monitoring. Cases allocation is decided administratively by the principal district and session judge, leading to inconsistent transfers, frequent changes of presiding officers, and lack of continuity in trial and evaluation. As a result, judges get limited and sporadic exposure to such cases, making it difficult to develop specialized expertise in juvenile justice adjudication. Second is inability to conduct target capacity building of children's court judges. In the absence of designated children's court, focused training of children's court judges becomes impractical, as there is no stable or identifiable group of judges. The designation remains functional rather than institutional, resulting in largely generic training. While the State Judicial Academy conducts dedicated POXO trainings, children's court responsibilities are addressed only briefly, causing trials and inquiries under the Juvenile Justice Act to receive secondary attention and leaving key judicial challenges insufficiently addressed. Now I'm coming to my second part, that is practical level challenges. First one is in this topic is balancing trial complexity with competing legal philosophies. Children's court judges are required to balance serious criminal trials with the rehabilitative and child-centric philosophy of the Juvenile Justice Act. This becomes particularly challenging in cases involving heinous offenses, adult victims, and prosecutorial demands for maximum punishment. In the absence of a specialized guidance and training, judges must navigate these competing legal approaches largely on their own, creating significant judicial and ethical challenges. Second topic is ambiguity in evaluating preliminary assessment and risk to presumption of innocence. There is limited clarity on how children's courts should evaluate preliminary assessment prepared by juvenile justice boards. These assessments are meant to examine the child's mental and physical capacity, understanding of consequences, and surrounding circumstances at the time of the alleged offense. However, delays in transfer often make such evaluation difficult. In some cases, the language used in assessment appears to suggest guilt, undermining the statutory presumption of innocence. With limited scope to correct these deficiencies, courts face challenges in ensuring fair and child friendly trials. Lack of clarity and mechanism for destruction of records. Earlier, Usama was saying that he is not getting the job due to the criminal complaint was lodged against her, and in police verification it comes that there is a criminal record against him. But section 24 and rule 14 of juvenile justice act says something else. Although orders of destruction of records are routinely passed under rule 14 of the juvenile justice rules, there is no clear mechanism to implement these directions. No authority has been assigned responsibility for record destruction, and compliance is rarely verified. This lack of a structured system seriously undermines the child's right to privacy and the objective of providing a genuine fresh start. Limited sensitization and child centric capacity for legal representation. Advocates appearing before children courts often lack adequate understanding of the child-centric philosophy of the Juvenile Justice Act proceedings, frequently follow the pattern of regular criminal trials with excessive adversarial conduct and aggressive cross-examination. This creates avoidable delays and make it difficult for the court to maintain child-friendly proceedings, placing an additional burden on judges to actively safeguard the child interest. Poor quality of tokenistic individual care plan. Although Section 19(2) mandates inclusion of an individual care plan in final orders, such plans are often prepared mechanically. They lack meaningful assessment of the child's psychological needs, education, vocational prospects, and family reintegration. Instead of serving as a rehabilitative tool, care plans frequently become a mere formality. Absence of a functional post order monitoring and rehabilitation framework. Despite a statutory provision under Section 22(1) and Rule 13(8) CCC, there is no effective system for post order monitoring. Monitoring authorities are not clearly identified, and rehabilitation cards under Form 14 are rarely maintained. This deprives the court of feedback on the child's progress and weakens the rehabilitative objects of the juvenile justice system. Absence of institutionalized best practices and systematic consistency. Children's court lack uniform SOPs and institutionalized best practices. Where good practices exist, they depend largely on individual judicial sensitivity rather than system design. There are no standard protocols for child friendly trials, media management, or family engagement, leading to wide variation across districts. These risk reducing children's court to a nominal designation rather than a specialized and consistently functional institution.
Thank you so much. A lot of issues, actually. If you'd like to add to those or and bring in your experience.
Thanks. A lot of work has the morning on preliminary assessments. This panel is really looking at children's courts and processes. Process in the children's court, and then there are some comments that I'd like to make about the process before the juvenile board, which is the court of first instance, as it were. With regard to the children's courts, there is an absolute lack of understanding that Section 19 is a process independent of an appeal. Now, whether or not there is an appeal that is preferred against the order passed by the juvenile board, a children's court, and the problem I think is also with the statute because it says children's court or sessions court. So there could be places in which there is no children's court, in which case it would go to a regular sessions court. On conducting a re-evaluation, as it were, on the order passed by the juvenile board. So whether or not the child themselves prefers an appeal, and this I don't know from where or how it has crept in, that largely I have seen there is a heavy dependence on the child filing an appeal under 101 of the statute in order to address the preliminary assessment order that has been passed by the juvenile board. So that is one major area of concern, because what is happening as a result is that the juvenile board is passing an order saying try as an adult, and the children's court is just taking that up. So trial is just is automatically taking place as an adult, when actually much before that trial you need to review that order whether or not the child has passed an appeal. Like there's a multi-layered level of protection granted to the child in the Juvenile Justice Act, which is very rarely you want me to use this, which is very rarely done by a children's court. That is number one. Number two is, from everything that has been said earlier, I am not sure what the distinction between a children's court and a sessions court is. In the sense that the only distinction that is there is if a children's court or a sessions court decides that it does not want to try a child as an adult, then it has to step into the shoes of the juvenile board and try the child as a child in the sessions court. And I think this is a huge statutory failing. If you don't want to try a child as a child, why does the statute not contemplate a remand back to the juvenile board? Why do you contemplate a sessions court stepping into the shoes of a juvenile justice board, which does not have the benefit of the two social worker members that the juvenile board has, right? And say try the child as a child in a sessions court. Now, how is a sessions court, which is otherwise dealing with a particular type of trial contemplated under the CRPC or BNSS or whatever, supposed to find, how is that sessions judge supposed to now try a child as a board would try a child under the JJ Act? It's a huge statutory problem, and for some reason we have, at least I don't know of a challenge that has been posed to this particular problem, that actually the act should have contemplated a remand back to the juvenile board, because the juvenile board has two social worker members attached to it. It has probation officers attached to it. There is a certain mechanism that it ought to do, which it is well aware of as far as the statute is concerned. That is my second concern with the statute as well as how children's courts function. The third is, I think what is happening in a lot of appeals, because I don't think Section 19 is effectively, the process contemplated under Section 19 is done at all. So it is in the context of an appeal that I will speak, because those are the only ones I have done also, is that there is a sessions judge is very accustomed to hearing in other trials expert witness testimony. And what happens when that sessions judge is reading a report that comes from NIMHANS, or in Bangalore it is largely from NIMHANS, or from other professionals of that kind, there is an automatic, very heavy reliance on the opinion of this particular entity, right? So you are sort of struggling in some way with the idea that you are facing an adverse opinion given by an expert. So these are the three, I think, major, I mean, I'm sure Sneha and others will point out various other things, but there is also a problem before the juvenile board that I would like to spend some time on. The first is the quality of lawyering. And it's very hard to speak of your brother and sister advocates sometimes, but the quality of what we take before a juvenile board and how much we, for the lack of saying it any other way, dig our heels in when you fight against a preliminary assessment before a board. A number of times I have seen lawyers either appointed by the Legal Services Authority or even private counsels. I don't think there is much of a distinction between the two when I say this, is that the order of preliminary assessment is a fait accompli. You think that it's a heinous offense and therefore the board is going to transfer, and you don't believe that there is something significant to be done by you while you are representing the child at that stage, right? What you bring to it, that is one. Two, I believe it is now no longer a problem before the juvenile board in Bangalore, but I believe it is a problem in other parts of Karnataka, and from what I have heard this morning, other parts of the state, that getting a copy of the assessment report that has been made by the psychologist or evaluators, actually not being given a copy and being told that you are not entitled to a copy. So you are arguing blind unless you have whatever screamed and shouted and done the theatrics to say, I need a copy in order to be able to argue, right? So this is the situation. And the third point that I'd make is the lack of infrastructure that our juvenile boards are operating with. Getting copies, which for us as lawyers in other courts is a matter of routine, right? We will get charge sheet copies, we will get FIR copies for the asking. You pay a fee and you will get a certified copy. There is no question of not getting a copy. Whereas before juvenile boards, the infrastructure is so poor that to file a copy application, receive a receipt, and actually be able to track where your copy is, and have a belief in a system that you are going to get the record that you need, whether it is photocopying machines, whether it is printers, whether it is what all of us take for granted in a regular adult court as court infrastructure, is very often missing before a juvenile board. And when you look at procedure and when you look at process, all of these questions are questions of delay in procedure and process. This is a matter of right, that you're entitled to every single thing that the prosecution or every single order that a juvenile board will pass against a child or for a child. You are entitled to a copy. You should not be, as lawyers, struggling to get these basic infrastructural things done in a juvenile board. I'll stop with that. I'm happy to take any other question.
Thank you. We all have a tendency to first get to the problems at the level of the board and then come to children's court. But Sneha, you have experience of children's court as well. So if you could come in and share, particularly like Gitanjali in the morning had said that, for a long time in Delhi, children's courts did not know that they are supposed to review the transfer orders. So what happens? Is it the appeal and when they're hearing an appeal, do they review? How do they review? Are the children's court aware of the process to be followed while reviewing a PA and a transfer order? If you could throw some light on some of these aspects, and then what are the challenges?
Yes, so let's first start with the basic question that most of the time, even the lawyers and the judges forum, nobody knows who is the children court. A lot of times, like if JJB today our orders that to police that okay, this case is being transferred as to be tried as an adult and produce the child tomorrow to the children's court. Now we go to district judge, we go to there is a criminal and civil side thing, we go there, we analyze all the list, and there is no clue who is the judge. So Delhi has their own thing that the senior most lawyer in the district is designated. That's a custom which is going on. So that's how we identify, and then we go and we mention the matter. Then it's told that, madam, this is not high court, there is no process of mentioning. So these are the basic challenges. To start with, that where is the jurisdiction of children court lies, right? Because like judges are here, but still to mention it again that in a district sessions court is the highest criminal court, right? Now saying that, imagine a situation that the most heinous crimes are being tackled by a judge and suddenly a child comes up with the police. And now it's been told that, sir, you also have to try this thing. And that's exactly thing is the word which I have heard. That's why I'm saying it here loud. Yes, and then the point is that okay, judge. It's not that judiciary also, we blame a lot of times we end up blaming judiciary, but there are judges which we have seen wants to work. But in that complexity, there are hundred of matters, and a person is a sessions judge, and suddenly he has to evolve and swap into another uh, soul altogether. So there's no clue how children's court will function from the very start, that how this case should be taken up. The entire JJ system to that particular judge, how to respond as a children court in the very first instance is also not clear. So that's where the section 19 most of the time gets missed, because if mostly police takes the child and produces the child. So no, if police doesn't know or mentions that section 19 order has to be passed, or a lawyer is there, or the judge itself knows, 19 stage always it lapses there, that he has to take the PA again. And there is also a point that there is an order after what Arul Verma said has, I think, mentioned that after that cognizance, there has to be an order of section 19 has to be forwarded to DSC LSC. It's not happening now. I am on the DSC LSC panel of lawyers, and it's not happening now. First thing. Second is that, that order is being passed, but the act also says that when PA is again reviewed by children's court, the experts which have already been referred by the JJB, children court can refer to some others also. This is also not known to most of the times, right? And also then the lawyer's role step in, that what should be and how should the lawyer argue there. Because there's one of the contention when children court says is that you have already argued before PA. Let me decide, this is more of an administrative thing and I have to do it. These are also the kind of, I'm not making it up anything, this is what actually happens in court. They said you have already taken the order, you have already argued, written submissions are there, now this is just an my administrative thing that it has come to me, and there is no argument as such written there. It's just a process which children's court has to review and then move forward, so you don't have a right. So then their problem comes in, which we in section 19 review, right? Yes. What was the other thing?
On the review process and do you have any other specific?
Yeah. So, see, basically, the role of children court regarding in terms of one is that as an appellate court, as in the trial, and the most important one is the original jurisdiction of a children court, which comes from CPCR Act and also from JJ Act, where the chapter of offences against children comes, right? So if there is, Delhi has this new circular going on, wherein if there is a child labor case registered, so that offence not go to JJB, it's going directly to children court. So those jurisdiction is also being broadening up now of children court, and we don't know how to deal with it. Yeah. Second thing is, I remember so the major question is, when a child is referred as an adult to the children's court after section 19, what is the status of this child? Is that child is now actually to be taken as an adult, or just the trial is it to be, because of the complexity of the matter? A lot of times, I think somebody in the previous panel has mentioned that because JJB cannot see the complexity of the case, that's why they referred the case to the more experienced judiciary, senior level. So what should be the status of that case? JJ, if you analyze the provisions, it's keep on the provisions of ICP, regular monitoring, then that child should not be, sent to jail. He should be, so which shows the intention that the child is still a child, irrespective of going to the children's court. And then, because accordingly, we have filed a bail in children's court under section 12, and that was it was not being filed, it was not taken up, so we had to really fight. Even at the court of high court, we have to, Justice Jyoti Singh was there, and we have to push for that, please ma'am, just make a comment that the registry should make a way for the appeals under JJ Act to be heard by the under section 12 or something like that. So these are the very practical issues which are there. The most important other thing was co-accused. when there is a co-accused and now the child is to be tried as an adult. Most of the separation of trial doesn't happen. And see, this is all is happening in Delhi. So, where ideally it's the best model JJ place to be seen. And everybody knows, like, I was shocked when I appeared before the children's court and I had to argue, and there was an order passed, and then we have to go to DJ and, in appeal and actually say. And that was one particular court in which every such kind of joint trial was being conducted, and this application has been dismissed every time. Then DJ has to specifically, the Cesari Central District, he has to specifically pass an order that, whenever you decide that it has to be there is a child involved, you will separate the trial. These kind of, I think, basic legalities, needs to be tackled at the children's court level.
Thank you. But, when you talk about a review and, getting another expert or seeking, opinion of other experts while reviewing, the question that comes up time and again is about application of judicial mind. And I know I've been speaking to Samresh ji, who's been feeling that, even for review, there should be some guidelines. Morning also somebody talked about guidelines. We did not initially begin with guidelines. Many of us opposed any form of guidelines, and we said, let, jurisprudence evolve around this with practice. However, some people pressed for it, and then we got guidelines through various high court judgments, and then came Barun Chand, Thakur, and we've now got the guidelines from NCPCR. The Delhi Commission has also come up with a set of guidelines around PA. But review is still a process where nothing much has come out. I don't know whether guidelines can really answer, but then if the question is application of judicial mind, then what does it really imply? When you're, going to be deciding on the question of whether to try a child as a child or as an adult.
I mean, I'm absolutely not of the view that in the hearing of an appeal, either under 101 or if you fail in that appeal and then you're in criminal revision before the High Court, I don't think there should be any fettering of how a judge ought to think, irrespective of the fact that you may face severe adversity, if at all you are before a bench of that kind, that it might be very difficult to argue in matters where the offense is, I'm not using the word heinous the way the Act contemplates the use of the word heinous, but gruesome offenses where children are in conflict with law or the subject matter of that proceeding. I don't think so. And I think that the body of work that has come from the Supreme Court and repeatedly comes from very High Court on the point of preliminary assessment, if you have lawyers arguing before a juvenile board, if you have a receptive juvenile board listening carefully to what has been laid down as the law as to what has to be done in a preliminary assessment and what a preliminary assessment tells you, right? Now, should we get into this? So, for example, one of the things that comes up very often before juvenile boards is that the 3-month for the preliminary assessment coincides in certain offenses because they are heinous nature with the filing of the charge sheet within 90 days for the contemplation of bail, etc., if that is a question at all. So there is a coinciding of this preliminary this report of preliminary assessment coming at the time that a charge sheet comes, right? Now, judges have said to me that they get a better understanding of the circumstances in which the offense has been committed from the charge sheet than they get from the report of preliminary assessment. So should materials that are presented in the charge sheet, including, say, a 164 statement of a victim, if a 164 statement, should that weigh upon the mind of a judge while of a magistrate while contemplating an order of preliminary assessment? Does it play a role? Sometimes there may be completely sometimes the order itself gives you, if they pass an order that really
tells us what they have been thinking while while creating a transfer order or saying that a child ought to be transferred to the children's court, then you have a lot of material that is in your arsenal as a lawyer before in appeal. But you really have to up the quality of the lawyering, both before the board and before a children's court in appeal. There is enough material. I can understand some years ago you did not have these judgments that were telling you, look at it this way, look at these factors, etc., that a series of judgments has now given us, right? But today, now you have the arsenal. So I would not at all be in favor of saying review ought to be treated in a particular way or an appeal has to be treated in a particular way. I think that is an act of judicial reasoning that judges are trained to do, and they have done, which is why you have your Barun Chandra Thakurs and you have Master Bolu and you have all of these judgments, right? So
Thanks for coming in there and a strong point of view. I'm sure there would be a differing point of view which we can take later. Let's hear Sandeep first, and we'll come to you.
Thank you so much. Since a lot has already been covered, I will share my views on the processes, practice, and challenges in children's courts. Now, prior to the case coming to the children's court, when the preliminary assessment is going on, I have one difficulty. The charge sheet was not filed. The law does not say that the preliminary assessment should happen after filing of the charge sheet. It happens in 3 months. My challenge was on what material should I make my submissions. I was making my submissions on the complaint of that victim. Beyond that, I had nothing to do. And based on that complaint, I was saying that this boy need not be treated as an adult. This is only an allegation. The charge sheet is not yet filed. Would that be considered? It was not considered. So now this matter, after the assessment of the psychologist based on the SIR, everything, and only the apprehension report, the matter once it is sent to the children's court. As a formality, we have it. But yes, as it was already told in the morning, very less number of cases go to the children's court, at least here in Hyderabad. But that one case, when it lands up there, the first step is a formal discussion on the reassessment of that preliminary assessment. Who does it? Only one judge, and me as a assisting counsel along with the public prosecutor. We are the only ones there making submissions on reassessment of the preliminary assessment. And as a formality, it proceeds further. Now, once it proceeds further, the case, my question is always, I had this one concern. Children's court for us here, we have also the special POCSO courts, and these children courts headed by the judge. What is the ambience and the functioning of that court? When the children's court, if you look at it otherwise, when the children going in POCSO offenses as victim, the setup is like this, that you have the child victim on one side closer to the judge, then you have the accused on the far end side, then you have the defense advocates in their full uniform. My question was, when the child turned up on the other side, you said this is the children's court, you follow child-friendly practice. What child-friendliness did you have when you put this boy in front of a judge in uniform, or before advocates in uniforms, and the victim is here, you are putting him there, behind a curtain? At least we have some children court which are far better. But then the problem was this, outside what happens is this. You have the regular adult accused, those who are in their handcuffs. This child is now standing beside them. When this child's number is called, case number is called, now he enters. He is made to stand there. How do we treat this child? Fold your hands, look down. This is the treatment that we say that we will reform this child by our practice in this demeanor. And this is supposed to be a rehabilitative step that we are undertaking. Now, these are challenges, of course, that we are facing on in the children's court when we are dealing with children who've been put at the far end. I don't know how adults will presume that I can make a child stand far from me and I want him to open up with me. I don't know how a mother would expect that you stand far away from me and you open up. You tell what is your problem. Where did you come from? That happens in your adversarial system. You put the accused far away because I understand you keep him close with the victim, but it may be intimidating to her. But in other cases, because we are not dealing with POCSO cases, I'm talking about generally, even if it's a murder case, who is the victim? The victim, you'll be surprised, will be an adult behind that box. This child is now outside behind in that curtain. This is the practice in our children's court. And this is a child-friendly ambience that we have in our children's court. So these are some of the challenges. If I just quickly wind up, that in rural areas, it is even more difficult. Telangana is in a very bad position. We have out of 33 districts, there are only 10 JJPs. So children from far off places are now in that one JJP. So they are assisted by one advocate. Now what happens after this order of a preliminary assessment and the child's case gets remitted to the children's court? Where is that children's court? Every district has a children's court there. So now again this child goes to that court. Now which advocate will you find there? So you are playing football with this boy. He is going from his actual native district. He is coming here. By the way, once he comes to the JJB, that is not where the boy is placed, because the observation homes are even lesser. So from far away place, you brought this child here. He does not meet his parents ever. They cannot travel here. And a literal bargaining that we have to do with the magistrates, this difficulty that we have when we do bail discussions. Bail conditions are generally like this. The petitioner CCL is directed to be enlarged on bail upon furnishing a parental bond of rupees 15,000 with 2 sureties for a like sum each. That is 30,000 rupees. And for which boy? That boy was there for 4 years, 4 months, 5 months. And from where will they get 30,000? And when the law says, under section 12, subsection 4, that within 1 week you produce the child, does that production happen? It is impossible, because the child is in a faraway home, observation home. You cannot bring that child. So I don't know what is happening unless somebody knows this provision and you file this petition. And until that petition is filed, no magistrate ever bothers. But this difficulty, it comes because you have regular magistrates acting as in-charge JJB magistrates. I personally feel this is a challenge, because the subject, by the time it creeps into you, we had one unique difficulty. A young magistrate had come, and in 1 year, these kind of orders were being passed, about 20,000, 30,000 for bail conditions. And by the time they understood the real picture of where these children are coming from, by that time the bail conditions were, there was a drastic difference. We were getting bail conditions for 3,000, 2,000 rupees. That magistrate got transferred. Another magistrate came. Again, now we are dealing with 20,000, 30,000 bail conditions. Because this magistrate, for them to understand whom they are dealing with, it takes time. And then they get transferred. If I may again just try to... so this trickle down of this knowledge that in generally these conferences that we do, previously also in Nalsar University, we had a wonderful session in which Fatima ma'am was also present. And but that knowledge, is it going down to that policeman who is handling children, to that magistrate in the homes, especially with advocates? We deal with children equally like any adult. In fact, worse than adults. In fact, I would say that the whole juvenile justice system treats children far worse than the adult system. I'll tell you how. I'm trying to just wind up, I'm sorry. I'll tell you how. For a theft case, we will take. If it is a theft case, if I am under trial and I am languishing in an adult prison, generally in 4 months or 5 months when the jail adalat is conducted, because nobody is filing bail for me, I want to get out. I can plead guilty, my remand is set off to the term duration that I've already stayed in the prison. Then I am released. What about a juvenile, a CCL boy in an observation home? Yesterday, I made a hearing for a CCL boy who is there in a theft case for 305 days. Nobody bothered. Nobody is there to file a petition. For a theft case, adults are getting released. A juvenile, I had this difficulty before a children's court. The sensitivity lacks in children's court also, because this is what, as madam rightly conveyed, That a regular sessions judge now suddenly you say that you become a child-friendly court, it's impossible. So a juvenile justice magistrate acting as the actual magistrate, judicial first class magistrate, acting as a juvenile principal magistrate. What the magistrate had done was, in my capacity, if I take myself as an example, as a judicial first class magistrate, a case was produced during remand. The difficulty was the Aadhaar card of a boy was produced. The Aadhaar card did not have the date, it had year as 2008. So the police said he is adult. When they produced, even though my other capacity is a principal magistrate of JJP, but in my regular capacity as a first class magistrate, I remanded him to adults prison. That boy went there. Nobody bothered him for what to do. He was brought from a very faraway district. His parents, nobody had, he was an orphan. But somehow his uncle managed to appoint a private advocate. That advocate never bothered to look at on what basis he is determined as 18 years old. And that when you don't have the complete date of birth, first of all, on what basis you are relying on an Aadhaar card? That argument was not made. 4 bails dismissed before the Children's Court acting as the special POCSO court. Because that offense pertained to POCSO offense. POCSO judge also did not ask. Dismissal after dismissal. The 4th bail is allowed with a condition of 30,000 rupees. That money he did not have. He's still languishing there. Then again, ultimately we noticed that case. Now where should we go? For the first step is determination of juvenility. You find out that this is the issue. So we somehow went to that far off district, we got the papers. We had to go to that same sessions judge who had dismissed 3 bail petitions, allowed the 4th bail petition, because that sessions judge was the Children's Court judge. So we filed the petition. That judge was not convinced, so wanted to give 2 weeks time to the police to investigate. They go to that native, they file a report. And ultimately when it came to the release, we had to go back to this magistrate in the juvenile justice board in which this magistrate was acting as a juvenile principal magistrate, and tell that because you in your regular capacity as a first class magistrate remanded this boy there, we roamed around all this while. After more than 155 days, we are now back to you. You please send him to the observation home and you please allow bail. Then the boy was transferred from there and put to the observation home. Then again it took some time. These are some challenges, and in conclusion, if I may say so, that overall the juvenile justice system for us practically is far more difficult to handle than the regular adult system. See, things are very fast there. For juveniles, they are very slow. Nobody knows what to do. There is no advocate who can assist at the stage of apprehension of that child. Then nobody is qualified enough. When in family matters, we say that for counseling, you need to have a certain number of days to become a certified counselor to handle families, adults. My surprise is, on what basis you allow anybody and everybody to get into the juvenile justice system and practice on children without even knowing the fundamentals of that law? That assistance, if you want, you should be a certified CCL practitioner. If you have that certificate course, then you go into that court and argue. Without that, anybody and everybody, because there's a lot of money here. 1.5 lakhs, 2 lakh rupees is what is charged for a CCL bail. It is far more than, and even worse, I will tell you. Juvenile bail takes much more than an adult bail. You go to the High Court, in 1 week it will get disposed. In our case, I will tell you what happens. Here, because we are acting in charges. Juvenile Justice Board is conducted once in a week. I filed my petition on Monday. My petition is posted for notice to PP on a specific day. Let us say it is Wednesday, is the JJB. For notice to PP, Wednesday. On Wednesday, I have served the notice. For counter of PP, next Wednesday. Next Wednesday, counter of PP is filed. For counter and hearing, for hearing and arguments, next Wednesday. That day we go. Both of us make our arguments. Reserved for orders that Wednesday. It takes us 4 weeks. I'm telling you the practical difficulties that we have. This is what we are facing. And when we request the judge that, Your Honors, this is a child case, kindly do it faster. Sir, I am in charge of 3 courts. A civil court as a junior civil judge, a criminal court as JFCM. I'm also in charge here I have other cases. I can't take it. Wednesday, sir, is my this thing. I will take it. So that's what I wanted to wind up with. I'm sorry for taking a lot of time.
Thank you. I'll ask Rohit now. Rohit, बहुत सारी समस्याएं सबने यहाँ पर शेयर किया कि चिल्ड्रंस कोर्ट को जब एकदम से क्रिमिनल एक ट्रायल करना होता है एक बच्चे का एडल्ट के जैसे और वहाँ साथ साथ उनको बच्चे के रिहैबिलिटेशन वाले एस्पेक्ट को भी देखना है वो कैसे बैलेंस कर पाते हैं नहीं कर पाते बहुत बड़ा एक चैलेंज है क्योंकि यहाँ तो बेसिक समझ में ही दिक्कत है और बच्चे कैसे महसूस करते हैं जब केस ट्रांसफर हो जाता है वो आप अगर थोड़ा शेयर
हेलो, मैं जगदलपुर से हूँ और जगदलपुर एक ट्राइबल एरिया है और ज़्यादातर बच्चे जो आते हैं वो ट्राइबल एरिया के होते हैं जो अनएजुकेटेड होते हैं और ज़्यादातर बच्चे जो गांव से आते हैं उनमें अगर कन्विक्शन से पहले क्या उनकी मनोस्थिति रहती है और कन्विक्शन के बाद क्या मनोस्थिति रहती है इस पे चर्चा करता हूँ और ये रियल बेस्ड स्टोरी है। एक बालक था जिसका जो एक गैंग रेप में फंसा हुआ था उसको 20 साल की सजा हो गई थी और उसके बाद जब वो हमारे संस्था में था तो वो सरवाइव कर रहा था। अभी क्या हो रहा है कि जो जितने बच्चे जो संस्थाओं में रहते हैं उन पे हम कहीं ना कहीं मेंटली प्रेशर ज्यादा होता है। कहीं ना कहीं बच्चे भी उनको मेंटली प्रेशर देते हैं कि नहीं अब तुम्हारा एडल्ट ट्रायल केस चल रहा है अब तुमको बड़ा सजा होगा और जब ये फेस करके निकल जाते हैं तो फिर जब सेंट्रल जेल ट्रांसफर होते हैं तो वहां कहीं ना कहीं वो समाज से कट जाते हैं सोसाइटी से कट जाते हैं फैमिली से कट जाते हैं कोई सपोर्ट नहीं मिलता है हम लोग भी हेल्पलेस हो जाते हैं। तो एक बच्चा था जिनका साची मैडम हेल्प किए थे तो वो बच्चा अभी बेल पे है और समाज की मुख्य धारा से मेन स्ट्रीम में जुड़ गया है। बाकी ऐसे बच्चे हैं जिनका कोई वहां पर सपोर्ट में नहीं है ना उनका अपील हो रहा है वो अपना सेकंड चांस का वेट कर रहे हैं कहीं कुछ नहीं हो पा रहा है उनके लिए। तो कहीं ना कहीं बच्चे डिस्टरबेंस है और ऐसे भी बच्चे हैं जो एक बच्चे का स्टोरी बताता हूँ जैसे वो अटेम्प्ट टू रेप में था उसको 7 साल का सजा हुआ था। अब वो जब 7 साल का सजा काट के निकला अब उसके बाद वो अशिक्षित था तो मोबाइल चला रहा था तो जिसमें उसको फ्रॉड कॉल आया था। अब फ्रॉड कॉल आया तो वो अभी सेक्सुअल अब्यूज वाले जो कॉल आते हैं उसमें वो फंस गया। अब उससे पैसे की मांग हुई तो पैसा वो नहीं दे पाया और उस डर से उसको पहले पता था कि मैं 7 साल का सजा काट के आया हूं और उसके बाद अब मैं कैसे फेस करूंगा बोल के वो सुसाइड कर लिया। तो सुसाइड ऐसे अभी हमारे यहाँ 2-4 केसेस हैं जो सुसाइड कर लेते हैं सिर्फ और सिर्फ ये एडल्ट ट्रायल की वजह से। कहीं ना कहीं एक लंबा प्रोसेस चलता है और कहीं ना कहीं रिलीफ नहीं मिल पाता इनको। तो ये बेसिस है यार।
Yeah, it's really sad that we've reached a stage जहाँ न्याय मिलना चाहिए उसके बदले हम उनको पुश कर रहे हैं कि वो सुइसाइड कर लें। We'll open the questions for audience and then do a last round for by way of solutions or recommendations that you all can have. Anyone would like to? Yes, Vipasha.
Thank you, Bharti. There are a few points that I would like to point out, like Ma'am was saying that a child could get, not being a child that has come to the children's court after getting transferred in PA, after PA, and the children's court decides that the child should be tried as in a juvenile justice board in the children's court. But I got to hear that they are getting transferred back to juvenile justice board from the children's court. Can that happen? It's happening.
No, that's that's the difficulty which Aarti was.
Exactly.
I'll be honest, I have got orders where the judge said to come back to the board. He's not honest. Tell the judge that.
So, Exactly. In your place, I would have done the same thing. Yes. Yeah. Exactly. So, like I said, in your place, I would have done the same thing, for the best interest of the child. Yeah. The other thing is that we were talking about the review thing that you were saying. So it's there either in the rule or the act, I couldn't find it, that they can take a second opinion by the experts, right? So over here I'm from West Bengal, we have medical boards for the JJB, giving a clinical psychologist giving their views, okay? But we have very limited number of clinical psychologists or the medical boards. So already for the juvenile justice board, we have limited numbers. How can we have a separate set of experts for the children's court? That's a practical, difficulty. The other thing I wanted to point out was in section 19.4 and rule 13.8.4, sub rule 4. We are talking about yearly review by the probation officer or the DCPU or the social worker in form 13. I've been talking to so many probation officers, it does not happen. Number one. Number two, yearly review. 365 days a child will be in a place of safety. And then once a year, there's a review to find out if the child is safe or unsafe. What are we talking about in this? So these things need to be addressed, just few of them I'm talking, then rest I'll continue later on. Thank you.
For
I think
one of the
we'll take a couple of questions and then you all can respond.
मैम यस मैम, मेरा भी एक प्रश्न तो नहीं बोल सकता मैं, एक सुझाव जैसा है, छोटा सा है। जैसे चिल्ड्रन कोर्ट में जो केसेस, मैं छत्तीसगढ़ से हूँ, रामनारायण वर्मा, तो जैसे चिल्ड्रन कोर्ट में केसेस ट्रांसफर हुए और उसमें जैसे कोई बच्चे का परीक्षा है या तो कोई और ओकेशन है जिसमें उसको छुट्टी मिलनी चाहिए, लेकिन चिल्ड्रन कोर्ट्स में स्पेशली बोल दिया जाता है कि सेक्शन 94 में कहाँ पे लिखा है कि चिल्ड्रन कोर्ट डिसाइड कर सकती है सेक्शन 94 के ऑर्डर्स करके। ऐसा 2 बच्चों के साथ हुआ कि उनको एग्जाम के लिए भी छुट्टी नहीं मिल पाई थी और उनके घर में एक शादी थी तो भी छुट्टी नहीं मिल पाई थी। उन्होंने जब ये रिक्वेस्ट लगाया था जब एडवोकेट ने, तो बोल दिया कि सेक्शन 94 जो सेक्शन 98 जो है वो छुट्टी के लिए, तो उसमें चिल्ड्रन कोर्ट का कहीं पे भी लिखा नहीं है, उसमें बोर्ड और समिति ही लिखा है, तो फिर उस बच्चे को छुट्टी नहीं मिल पाई थी। एक तो पहला है, और एक दूसरा जो मैम ने बोले फॉर्म 13 जहाँ पे प्रोबेशन ऑफिसर्स को रिपोर्ट सबमिट करनी होती है एनुअल में, वो फाइनल ऑर्डर्स में भी नहीं मंगाया जाता, और जब 21 का होता है बच्चा उस टाइम मंगाते हैं और उसमें ऑर्डर कर देते हैं कि आप इसको जेल भेज दो, सिंपल एक लाइन में लिख देते हैं कि आप इसको जेल भेज दो बिना कोई असेसमेंट किए। तो ये दिक्कतें भी है छत्तीसगढ़ में। थैंक यू मैम।
Yeah, I'm Shruti Jain and I'm a principal magistrate from Bhopal. So I want to put forth my view as a principal magistrate because a lot has been said about the working of the principal magistrates and everything. So there are practical difficulties which we face many times. Being in Bhopal, which is capital of Madhya Pradesh, there's no permanent probation officer. I'm having a probation officer for only 3 days. So I have to adjust my bails and everything accordingly. So I try to, because we have a board for 6 days, regular board. But the thing is, we don't have a probation officer all the days. I had been writing for all these problems throughout, but I'm not getting the solution. It is being said that that we are into that process. So this is one of the difficulties. And as we were discussing about bail, so rightly said that many a times they put conditions like 15,000 or 20,000 bail. But in certain cases, the situation is that a child who is again and again coming to us and committing crime again and again, if we don't put such conditions, they are only interested till the stage of bail. After that, they will they will not be coming and attending the proceedings or the inquiry process before us. And then we have to keep on sending the notices to please come before us, and we'll conduct the inquiry properly. So these are the difficulties which we face practically. And other aspect, which I don't know if I should put forth it here or not, we have certain administrative things also. Being a principal magistrate, obviously we are expected to work in a very, very child friendly manner and approach, but certain limitations which we have to follow. Being a judicial officer, those administrative things are there for us. We have to give units, we have to do certain benchmarks which are there for us, being in a regular court or being a principal magistrate. So these things are there with us also. So this needs to be taken care of, and it needs to be taken care of at a national level, so that there's parity in every state and in every JJB. So that can be worked upon, and we will make things better if there's parity in every state and every JJB. So this is what I wanted to say. Thank you.
Yes, sure. This is Emilio from Goa. I just want to narrate a case and a positive experience from the Children's Court. We work very closely with the Children's Court. And every CCL who comes to Children's Court, there is a counselor present because the judge mandates a counselor to be present along with the CCL. That's one thing. Secondly, how we got into intervention was the judge who is presently in the Children's Court was first the principal magistrate of the Juvenile Justice Board. She was the one who basically attended the first round, second round, third round regional consultations by the Supreme Court. Justice Mundkur led that, and she got that experience and learning. So for her, it was having a counselor present for every CCL. Just to narrate one thing, I'm also a fit person in Goa for taking custody of children. So she issued a notice to me and she called me and said, there is a girl who is 1.5 years in the observation home. She's 19 now. Can we do something? She is now doing 3rd year in home science. It's a degree course. She's released from the observation home, given in my custody. We put her in a boarding institution where she is now on her own going. The condition was the judge did not wanted to release her to the family because the mother was paralyzed. She was not listening to the father. So the home situation was not positive for her to be released. But our condition for her to be taken in my custody was every week, the parents had to come and meet this child in our office. So we have every Fridays where this child meets the parent. We have monitoring, and every 2 months we send a report to the Children's Court, that's a POCSO court in Goa. So there are positive stories also, okay, from judges who have been attending trainings and listening to the various innovations people talk about. Well, this is just a sharing from my side.
I mean, where you have
Hello.
Extraordinary principal magistrates who will not expect a bail application to come but still consider. I mean, we've all had that rare experience before, a magistrate who has enlarged someone on bail even without a formal bail application being filed. So where you have extraordinary judicial officers or extraordinary sessions judges, you will see a terrific implementation on many levels of the Juvenile Justice Act. My only thing is, I think they're too few in number. That's the.
And what should be systemic, what should be a systemic institutionalized practice is dependent on individual sensitivities. So that's by and large where we are. Any other questions? Because comments, yeah, we've got enough. Yeah. आप कुछ कहना चाहेंगे समरेश जी?
एक्चुअली मैम ये बात सही है कि जब बार बार जो है वो कोई आता है तो एक बीइंग अ जज हम लोग को ये लगता है कि इसको मेन स्ट्रीम में लाने के लिए जो है वो कहीं ना कहीं हमको कुछ रिस्ट्रिक्शंस लगाने पड़ेंगे सो दैट कि हम उसको कुछ कंट्रोल कर सके. So that's why she was saying that we impose such tough conditions to the CCL boys so that हम उनको रिस्ट्रिक्ट कर सके और हम जो है वो उनको रोक के जो है वो मेन स्ट्रीम में ला सके. बाकी सर ने जैसा बोला सर, ऑनरेबल जस्टिस हैज सेड द बॉटम लाइन.
Okay.
Children's court saying that this is heinous. Anyway, this would come to us. Let us just proceed with trial. And there have been, of course, Tirumurthy's judgment that we have. And there are many such cases that we have discovered in the process of our research where it's gone directly to the children's court.
नहीं, but
It's gone because the police have come and produced and said, yes, this is
can't go.
17.
Because session court cannot take direct cognizance
That's
of
right, sir.
any of the offences.
That's
All
right,
the
but they
offences
have in
should be
POXO
committed to-
cases. POXO cases, they have gone ahead and done it, and they've said we are the POXO special court. We can take direct cognizance. It would anyway come to us, so we will proceed with trial.
That is
Children's courts are also POXO courts,
Yes.
right? So
The second thing I want to ask, I think, for the panel to reflect on the evaluation aspect. We've spent a lot of time talking about the children's court functioning, but if we can also hear from the panel, how is that evaluation? What grounds would you look at? Answer to you because aap children's court mein hai. What would you say is enough material for you to say that this child is capable of making meaningful contribution to society, and this child is not? And for the panel to say, as lawyers, what kind of material would you say is such an evaluation even possible in any objective way? एंड द प्रोबेशन ऑफिसर, अगर आप भी बता सकते हैं, मतलब आपके रिपोर्ट्स में जो आप भेजते हैं, क्या आप ये भी लिखते हैं कि उनको क्या क्या सर्विसेज दिलाई गई? क्योंकि चिल्ड्रंस कोर्ट को वो भी देखना है कि किस हद तक इस बच्चे को वो रिफॉर्मेटिव सर्विसेज मिली है, और अगर किसी बच्चे को बिल्कुल ही नहीं मिली है, स्टाफ वेकेंसीज है, कोई भी प्रोग्राम वहां पे नहीं चल रहा है, डज दैट मीन दैट दैट चाइल्ड हैज नॉट shown any sign of reformation?
yeah, will you start on that? And also sort of wind up with some
Sure.
yeah.
I just want to say that we're all here because of the addition of this provision of preliminary assessment and trial as an adult. Now, to what extent have we spent time examining, either as people who work in the child rights space or as lawyers or as judges, whether the provision actually merits what it sets out to do? So I actually believe that it's misplaced. We were okay with every child being tried as a child under 18. That ought to have been the position. We have now put in what appears to be a very unrealistic expectation on the system and on lawyering. How do you assess this? And what happens when you have a situation where, and this is a practical question, how are you going to address a situation where the preliminary assessment has taken place 8 months after the child has been apprehended, an order has been passed to be tried as an adult, We have challenged that order in an appeal, and we have argued that the preliminary assessment that was conducted was not done well enough. And the judges said, okay, I will conditionally set aside this order, redo the preliminary investigation. Now you have a child who was a child, 12 months, 1 year, 1.5 years has passed while all this is going on. What assessment will you make now of that child at age 18 and a half or 19 that child is at? What answer do we have to these particular questions? That unrealistic expectations on officers under the Act, individual care plans. Who is monitoring the quality of these individual care plans? When are they drawn up? Who is to oversee them? A lot of pressure on probation officers. A lot of us know how SIRs are done in terms of the mechanical nature. We've also seen mechanical transfer orders where what has been changed is the offenses, the crime number, the police station, and maybe 1 or 2 lines on reasoning. We've brought, in some way, this is something that we have brought on ourselves, or whatever, we have been thrust into this by virtue of the insertion of this one provision. And that has come because of a few persons under the age of 18. Now I don't think there's going to be a success in a constitutional challenge to it, which is the only thing that I think is left undone in the sense of challenging whether categorizing people between the ages of 16 to 18 is a classification that ought to actually be something that is constitutionally tenable. But barring going down that road, we are stuck with a statute that places very unrealistic expectations on juvenile boards, on experts of psychiatrists, what they call psychosocial experts, etc., in making this assessment on these 4 criteria. Who is assessed on these 4 criteria? What meaningful assessment are you going to get? And we are all working with this in order, which leaves you with only one thing I think left to do, which is to really up the level of the quality of lawyering and representation of children. Fine reading of reports, get SIRs, make really creative arguments, use all the judgments that have been given to you by Supreme Court, High Courts, etc. Carve out that exclusive exception that your particular client finds themselves in, which is happening in bits and pieces. But otherwise, I think your question, it can't be answered. We're stuck. And we're working in a relatively broken down system, which is broken at the end of the statute, I think, in this particular case. So it's an impasse. I'm not sure we have any way in which to address this.
Can I ask one? This is a...
I thought there will be dead silence after that. But
Sorry.
Okay.
I'll be very brief. In fact, my question is more about my attempt to educate myself and probably few others as well. In fact, I'm curious to know about what happens after transfer, adult-like trial, dispositional order, and the child is sent to, in all probability, that place of safety where he spends, say, 3 years and then maybe transferred to jail. Maybe transferred to jail, of course. After 3 years, there would be reassessment. So is that reassessment really happening? Is there some data available that how many children who have been tried? And what tools are being used for that reassessment and how meaningful those tools are?
Sorry.
So the final order, the transfer order said that the child has made tremendous progress in the in the place of safety, but leaving him would motivate him to do more crimes like that, and therefore it is not safe to leave him out. He should be transferred to prison. This order was challenged in the High Court. The High Court judge said giving him release or any kind of relief would mean that we would open floodgates for all the other cases like that. Now this case is pending in front of the Supreme Court and we're waiting for an order. But this child spent 7 years, ये 7 साल 6-7 साल ये बच्चा अंदर था एंड वो वहाँ का गेट कीपर अकाउंटेंट सारा काम करता था. ही वॉज जब उसको ट्रांसफर किया तो पूरा इंक्लूडिंग द सुपरिंटेंडेंट से लेके सब लोग रो रहे थे. एंड इवन नाउ द होम इज कंटिन्यूसली गोइंग एंड मीटिंग हिम. और ऐसे एक नहीं 5 बच्चे हैं जिनको ट्रांसफर करते जा रहे हैं अडल्ट सिस्टम में. एंड आई मीन ऑनेस्टली व्हाट इज द पॉइंट, जब दिस इंसिडेंट हैपेंड ऑल द चिल्ड्रन इन द होम वर लाइक अगर इसको ट्रांसफर कर दिया तो हमको तो कर ही देंगे. अगर इसने इतना अच्छा प्रोग्रेस दिखा के भी इसको ट्रांसफर कर दिया देन आई एम डेफिनेटली गोइंग टू गेट ट्रांसफर्ड. सो ये आई मीन आई थिंक रोहित सर would be able to share more, but that's sorry, I just got super passionate.
बट मैम ये मैं बोलना चाहूंगा कि जो रिव्यूइंग प्रोसेस है वो मतलब मध्य प्रदेश का मैं बता सकता हूँ कि वहां पर जो है वो स्ट्रिक्टली और स्ट्रिक्ट सेंस में फॉलो हो ही नहीं रहा है. अगर आप डाटा बोलेंगे या कुछ भी कहेंगे वो स्ट्रिक्टली फॉलो नहीं हो रहा है. और प्लेस ऑफ सेफ्टी या ईयरली जो रिव्यू होना चाहिए वो हर एक केसेस में चिल्ड्रंस कोर्ट के द्वारा अगर कभी भी जो है वो कुछ पनिशमेंट या कुछ भी दिया जा रहा है तो वो वहां पर फॉलो अप नहीं हो रहा है.
वो कहीं भी नहीं हो रहा है
जी.
मध्य प्रदेश एक्सेप्शन नहीं है वहाँ. I'll have to I'm afraid wind up, but then wind up in the sense there's one case which I want Sneha to share on that point of reassessment. And the first time when something has come out for the monitoring authority which is mentioned in the law in Delhi, if you could share.
So it was a children court matter, and after we flagged it that it's a children court, the judge called Anant, and we had like what we should do, how we should proceed. We are very much into keen to see that how we should decide and rehabilitate this child, how I'm supposed to do, because the minimum, it's a POXO case, and minimum sentence was 10 years, right? So the trick was that we gave a point that maybe where are the reports at the time of sentencing. She called up and she said ki what should I do. So we said ki ma'am, where are the reports, just call the PO and there would be this periodic reports. The PO was called and there was nothing because once the I don't know, there is no system of even in the JJB also. In JJB also, when the child is out on bail, there is no follow-up as such. Right? It's a paper, there is a order again and again coming, but there is no follow-up as such on ground what the child is, where the child is by the PO. I'm telling about every state have every other practice, so please don't say that we do. Delhi doesn't have, because Delhi mein PO sits in the same JJB and just only do the SIR, see once the child, that's it. This is Delhi, right? And then I saw this PO who has been like following up and so much of work to do, right? So in this case, she took up all of the, then monitoring, another PO was appointed by the children court magistrate, judge, and then she again asked for another report. But then the point was that how should we track that much of, because the case has been for 7 years. So nobody know how to track that case and the development and the progress or reformation. So ultimately she had to pass an order for like committing him for 10 years, sentencing him, but then we have challenged it. But there was the point when monitoring authority was appointed. So for later on, like that came into practice that monitoring authority will be there in such case. I will sum up my thing in just three of the points, major points. One is that, children court, there are differences. I beg to differ. I love children court. And anybody who is from criminal law will love children court, because JJB makes it too much of welfare point of view. No offense to anyone, but then because there are various stakeholders, right? And you have to wait for this thing and that thing. Like suppose I'll share a case law. There was an NDPS offense and the police produced the child. and there was no recovery. First the very ingredient actus reus has to be there. There has to be some recovery of. There was nothing. There was an FIR, and the police was saying that this is the thing. It comes under heinous, and so this is the thing. I need some time to file the charge sheet. That's it. We kept on saying that first let the offense be prima facie ingredients would be there. No. So that is something very challenging before JJB in children's court, because being a children's court, first they do this thing that, okay, where is that? So I am very happy, and the generally children somehow CCLs are also like, okay madam वहाँ कर दो, वहाँ पे बहुत जल्दी bail मिल जाती है, वो बड़े वाले तो छूट गए. So the case in this juvenile had 1,000 days incarcerated, and Justice Jyoti Singh has specifically had written in her thing that order that this child has been reformed. There is no point. So that order, the another two cases also we have used that particular. So that was the power of probation officer's report and everything. And because we can't ignore criminal law altogether there. The actus reus and everything comes up place. JJB sometimes become too much of welfare approach. I'm sorry to say this thing, but yeah. And second thing on your question, evaluation of PA or review of PA, right? Nimhan sir is not there, no? Shikhar sir has left. Okay. So there is this two format which Nimhan has proposed, right? One was for mental health when a child comes into CCI and tracking that. And this another one was for PA assessment, right? Now, what is happening? It was a very good initiative, of course, but in Delhi, most of the JJBs, they're calling for PMD report. It's called PMD report there, physical, mental, and drug assessment. So whenever a child goes into CCI, any home observation, place of safety, whatever you call it, there is a PMD report. First order is for PMD report. First production happened, and they called SIR and PMD to be submitted on the next hearing. This PMD report happens irrespective of the status of the child, right? And this is the second format, which is used for PA. And there is this thing, the third point, circumstances in which the entire confession is written, because I'm sure the child must have not been explained that you just have to say what were your circumstances, you have been addicted, you have been doing this, and that's why you did it. No, he says, ma'am, ye hua tha, this is this, that's how I've been taken, isne chaku mara, ye this way. The entire allegation is there. Now our challenge is that report is on record, right? And I keep on arguing or whosoever is, and the judge says, madam, please try to understand this. He's saying that he has committed this gruesome act. So how should we not transfer him to adult? How should I ignore me? Tell me a way to ignore this thing. So we keep on saying that this cannot be this doesn't says that, this doesn't. He said there is a confession, this says. Tell me how to ignore this thing. Yes. Because that report says very much, see, have you seen PMD reports? Mental capacity, no mental disability. That's how it comes in one line, right? This is exactly the statement. No mental, physical capacity, no physical capacity. That's it. Then comes circumstances of alleging offenses, this. The child has smoking and has manipulative tendencies. That's it. Child is fit to be tried as an adult. That's the report. Maximum reports are like this.
Saying that JJBs are very welfare oriented, does that mean that they just want to keep the child in the institution?
Yeah, I mean,
that is the welfare orientation, quote unquote.
Yes. Because see, family institution, no, family has to come first. But then they keep on that we will rehabilitate in the institution.
हम यहाँ rehabilitate करेंगे अंदर रख के बंद रख के बच्चे
Yes, my point is you can rehabilitate in the family.
Just wanted to clarify. Thank you.
Is that synonymous with transfer, or is there a kind of discretion? And what kind of
course it's discretion? No, not synonymous. Not synonymous. There is a very typical image of child also, no? Like the play has been there. The child has to be poor. The child has to be from a marginalized society. Then that case is fixed for not transferring because there are certain conditions. If a person from a privileged background, both parents are working, they're like, why this child has been committed, irrespective of his mental health, his physical capacity, what has the trauma he has been suffering, nothing matters. So there is a very typical, way of seeing a victim or a CCL in the system.
I think the point is that, the way these reports are being used, and used to transfer children for
It's
adult
actually
like
not that
trials.
report also, right? It's a PMD report, which
Yeah,
is
the
being,
PMD report.
yes, yes.
Yeah. So different formats have been created. Much confusion around those formats prevails, and they are used by different authorities according to their whims and
So I
fancies.
mean, even in a petty offense,
Nothing really is happening for the child per se. I have to.
Can I just make a small point?
Wow. So, if you, my first thing was when I was speaking to the panelists was that, do you have any positive practice that you can share? So one thing came out that, not many cases are being transferred. I thought that was positive, and my second thought was not at all. That's not where we want to begin. Yeah, nobody has data. Nobody really has data, as to how many cases are being transferred, and after transfer and review or appeal, whether they are they are being tried as adults or being retained as children.
I don't think we're even entitled to this information under RTI because of the confidentiality clause.
Right, and despite annual conferences of the Supreme Court, we don't have this data. Let me put it like that. So
I just want to make two.
whether it's possible to take that as a recommendation from here and start working on that, if there is a group that comes up and we can start working, that's something that can be definitely
I was
considered.
just wondering, this issue that you raised about this MHD report or whatever PMD report, something, whatever that is. Now, can that, because obviously this kind of an assessment, and I'm a psychiatrist, so I have done several of these assessments myself, but if an assessment is done in this format, it is obviously not in keeping with the tenets of what assistance a mental health expert is supposed to provide. So can that not itself be challenged, A? B, if there is self-incriminating material written in it, can that not be refused or declined? Can that not be withdrawn? Because, I mean, you're not supposed to mention information like that in the first place. That is all said in confidentiality, and that's not what the court is asking us either, isn't it? They're asking us to do an assessment of the child's larger capacity, circumstances, and so on. The one other point, I'm listening to Sir, and the point that Swagata raised about how do you really assess, reformation and rehabilitation. See, young people don't premeditate offense. A lot of the times, the so-called offense is reactive, isn't it? It is occurring through vulnerabilities, through pathways to offense. So when we are assessing rehabilitation and reformation, is it enough to confine this young person in four walls for years on end and then claim reformation, rehabilitation, or should there be an ecological truth to it? So which means, where does the point of reintegrating this person into community, continuing the outreach, continuing the support over a period of time, and then, really assessing these things arise? So I know, based on the discussions, I know that there are, several steps, but I think in the larger scheme of things, we need to understand the ecological validity of reformation, not just behavior and confined walls.
Yeah, I think that all of us would agree on that. Yeah.
Can I just say one thing? If you remember in the morning, Justice Nagaratna said that the annual Supreme Court conference this year, she said that she's thinking about having a review of the JJ Act as one of the topics or the subject of the annual review. So when you say that, data is not available with regard to, the number of cases that have been transferred and so on, I think you can start working on that, maybe discuss it with Justice Nagaratna so that she can, tell the JJBs and the high courts to provide that data. Okay. Yeah.
But we all send large parts of data, and we really don't know what happens to the data when it reaches the Supreme Court in terms of further analysis, further practice, etc.
Yeah. Okay. So, all right. That's a good point, but maybe I can just ask Justice Nagaratna what happens to that data.
Yes, please.
This is why I had asked earlier whether the JJCs have a secretariat. One of the things that we had said was that every JJC should have a secretariat because the judges are busy otherwise, and the secretariat will take care of the work. Now, the Supreme Court had a secretariat. I don't know whether it still has one or not. So that secretariat can analyze the data and it can be shared. It should be shared, right? So at least for maybe last year, if the data is still available, but for this year's conference, the data can be analyzed and shared. Okay, that is one request that I want to make. The second request that I want to make is that, this review procedure of what's actually happening. Now, there are two things, one is the procedure, that's procedural aspect. All right, if there's a violation of the procedure, the thing is wrong, or if the procedure is unreasonable, it is unconstitutional. The second aspect is the substantive law, right? So if the procedure is bad, it can be unconstitutional. If the substantive law is bad, it can be unconstitutional. Now, on this review procedure that has been discussed, it appears to me, I was just seeing the act, it appears to me that it is clearly unconstitutional, both on the procedural aspect as well as on the substantive aspect, which is why I had requested that if you could share some of these orders, right? So if, the rapporteurs can focus on the discussion that has taken place in this session on these two aspects of procedure as well as substantive law, perhaps a challenge can be mounted. The third thing is that
A challenge to
the procedure.
The 16 to 18 classification.
Yeah. Because it sets apart, it puts them in a procedure which is clearly unconstitutional, right? I can't see how, when an order is set aside that the preliminary assessment is bad, the same judge will conduct the preliminary assessment, because that's not the function of the judge, number one. Number two, the reason for a preliminary assessment is that before the JJB, you have a principal magistrate and social workers, which you don't have before the children's court. So I have no doubt that it is unconstitutional. The third thing is that, there are issues which, pertain to the functioning of the JJBs. Like Ms. Jain said, you have a very valid point that you are working under a constraint. These things, if they are brought to the notice of the Supreme Court and, probation and all that, if these things are brought to the notice of the Supreme Court while they are discussing in this annual conference on the functioning, maybe some good will come out of it, or at least the high courts will be prompted to do something. I find it strange that in Telangana you have, children who are in some place and the observation home is in another place, the JJB is in a third place. I mean, it can't function like that.
And that's not just Telangana.
Yeah.
That's not just
Telangana. Yeah, may not be, but I mean, Telangana was
Yeah.
mentioned, but
Yeah.
if it's there in other places, it makes it worse.
Yes. But well, it's not as if there's no awareness about it. There is information about the fact that,
the awareness may be with you.
No.
I'm not sure whether it's with Justice Nagaratna. If she's aware of it, I think she should be
I just want to add that, in fact, data has been collected for the last 3 years. And I think there are many people in this room who have contributed to the data. The reliability of that data is a huge question mark. We ourselves have been part of the analysis of such data, and you will be surprised. The data will tell you that in a petty offense, the child has been, preliminary assessment has been done, and the child has been transferred to the children's court for trial as an adult in a petty offense. And then we ask them that, is this real? Is this for real that in petty offenses you're sending? Then they go back and say, no, madam, this number is wrong. So who is feeding that data? What is their understanding of this data? There is a report. The last conference, a report has been circulated to everybody. We can share it. But I don't think any of us will
Would
say
rely
with
on
confidence that data is reliable. We need an MIS.
Yeah, but
We need the JJ system cannot be opaque. In the name of confidentiality, we are absolutely doing great disservice. We have no data on how many PAs, how many transfers, how many Section 19(1) procedures followed, how many evaluations done, how many sent to jail, how many released. We don't have that data.
Also,
All in the
it
name
may
of
still
protecting
be
children.
it may still be easier to get data from JJBs, but from children's courts it's very difficult because
there is no designated children's court there.
No, that's
Actually,
right.
every session judge is working as a children's court
Correct.
judge.
You're right. You're right on that. You see, now if Justice Nagaratna says in that annual conference that, listen, there is no regular children's court in so many states, somebody he will have to wake up. You know, the high courts will have to wake up, or the state government will have to wake up. All right.
There's also a lack of computerization at the level of the JJB, so there's no e-court systems that function.
Yeah,
So
yeah.
even if you had a researcher who was
No.
willing to sit with the raw data of the e-courts and manually code, we're not able to do it. Because I had initially thought of a project. I said, I'd sit with the e-courts and I code raw. I don't need a software to extract I'll do it manually. But it doesn't exist. So if you were to ask me in how many, which I think is data that is important, in how many cases of murder, or in how many cases of sexual assault, or in how many cases of POXO, or how many cases of dacoity are orders being passed, because then that tells us whether the nature of the offense weighs on the mind of a magistrate or not. There is no way, even if you have a researcher willing to do it, you don't have a way of accessing it.
Yeah, but the JJB will have that, or the children's court will have that. Somebody will have that information. A researcher may not.
Actually, don't know if JJB has it, sir.
Yeah,
Actually, sir,
Bangalore's JJB, if you were to ask the JJB, tell me offhand how many cases of murder you are currently trying, I don't think they'd be able to give you, they would
I'm
have
not
to
sure.
manually calculate it.
No,
not sure.
Aarti, I don't quite agree with this, because it's all the JJBs, at least I can talk for Tamil Nadu. In Tamil Nadu, it's quite, it's all computerized.
Yeah, in
If you're-
MP as well. In MP as well, all JJBs are computerized, sir. And MP is also working for MIS system, sir. So that each and every stakeholder is accountable for his data. If CICL is going to observation home, then the superintendent of observation home will fill up the MIS, and ID and password would be given to him, so that he can fill the data regarding it. If CICL is अगर फैमिली में चला गया सर, देन फिर अगेन वो अधीक्षक जो रहेगा वो फिर डाटा को जो है वो फिलअप करेगा सर. तो इस तरीके से हर एक स्टेक होल्डर्स की रिस्पॉन्सिबिलिटीज को फिक्स करते हुए MIS पे वर्क अपॉन हो रहा है. जल्दी हम लोग इम्प्लीमेंट कर लेंगे सर, so that the data would be correct and accurate.
The point on data is definitely something which is coming out very strongly, and we need to figure out ways of how to collect that and also bring it to the national level.
What about you?
I think, ma'am, no, so then I have 3 hands here. Ma'am, all right. Okay, ma'am, am I supposed to?
Equality of dismay is what you are. The equality of dismay.
Yeah, we can definitely discuss a lot more over chai and tomorrow as well. I'm sure there are many issues that will come up tomorrow. I really wanted to give him the last word. Rohit wanted to talk about progress reports, something that we haven't heard about at all.
जैसे प्रोग्रेस रिपोर्ट है वो मेनली हम क्या है साल भर का ऑब्जर्वेशन होता है उसमें, और जैसे अगर कुछ वोकेशनल कोर्स हो रहे हैं तो उसको भी मेंशन करते हैं। अगर वोकेशनल कोर्स या स्किल डेवलपमेंट के कोई कोर्स नहीं हो रहे तो उसके अंदर क्या सुधार आ रहे हैं, क्या प्रोग्रेस है, उसको हम मेंशन करते हैं। और ज़्यादातर कोई सिफारिश नहीं होता है, मेनली उसके ऊपर जो उसके जो अप्रोच है संस्था के अकॉर्डिंग, और कोई बच्चे हैं उनको क्या वो उनके साथ क्या ट्रीट कर रहा है, उसके वेल बिहेवियर, ये सबको अपन मेंशन करके उसमें भेजते हैं।
आई थिंक कुछ गुड प्रैक्टिसेस हमको भी स्टार्ट करना पड़ेगा इन टर्म्स ऑफ डॉक्यूमेंटिंग सम गुड प्रैक्टिसेस। तो आपके यहाँ जो हो रहा है, अगर वो एक ऐसी चीज है जो जिससे दूसरे स्टेट्स में सीखा जा सकता है, उसको डॉक्यूमेंट करने में साची आप मदद कर सकते हैं। और ऐसे ही आप लोगों के बाकियों के स्टेट्स में कुछ ऐसे गुड प्रैक्टिसेस हैं, लेट्स स्टार्ट डॉक्यूमेंटिंग देम। एंड आई कीप गोइंग बैक टू द फर्स्ट document that we had produced, where we had compiled a set of orders of passed by one of the juvenile justice boards in Delhi. तो वैसा ही वो एक अपडेशन अगर बाकी दिल्ली से होता रहे और बाकी स्टेट्स में भी कंपाइलेशन हो, क्योंकि जेजेबी के ऑर्डर्स का कंपाइलेशन आपको कहीं और मिलेगा नहीं, पर डेफिनेटली रिडैक्ट करके, आइडेंटिफाइंग इंफॉर्मेशन रिडैक्ट करके वो हो सकता है। Let's keep trying at documenting as much as we possibly can, and thank you everyone for such a lively discussion. Thank you to all the panelists.
Thank you very much, ma'am.